May I ask, officer, how you were able to track the telephone to the defendant?
He kept using it, making calls. He was actually talking on it when we went to arrest him.
That's not true. I was checking my messages.
Shh. And, officer, the defendant was found to have this stolen telephone marked and identified as People's Exhibit C in his possession at the time that you apprehended him, right, officer?
Yes, sir.
Right in his hand?
Yes, sir.
Thank you, officer. I have no further questions.
$60 credit for time served, the rest suspended. I'll have one drink with you.
You're inappropriate, and your offer is rejected.
So, you arrested my client for being in possession of stolen merchandise?
No, I arrested him for stealing the merchandise.
And how do you know he's the one who took it?
He told me. He said it looked like his phone and he took it by mistake.
Do you know that not to be true?
I have phone records to show over 36 calls received by the stolen phone after it was reported missing. The ring on the phone was Beethoven's Fifth Symphony. His phone ring was the theme to SpongeBob. We can also prove he played the messages on the stolen phone's voicemail, so at some point he had to know it wasn't his phone.
Okay, thanks.
That's it? Shh. What the hell was that? You barely touched him.
Just be quiet, Jerome.
Mr. Peters, anything else?
Prosecution rests, Your Honor.
Very well. Ms. Sims?
Defense rests, Judge.
Rest.
Jerome?
Lady, I am a human being.
Okay, again with the human being defense. I know what I am doing. Can you just trust me?
Trust you. Trust you to do what? You're deliberately trying to lose, and I know it. You want me in jail.
You finished?
No, I will get you. When this is all over, I will get you. And if you think getting me stuck in jail is gonna protect you, you are wrong.
Are you threatening me, Jerome? You gonna add violent crime to your already impressive resume?
Okay. Mr. Peters, I'll hear from you.
May it please the court? The defendant, Jerome Harris, was found with the stolen merchandise in his possession. He never returned it. Moreover, he had to know that the cell phone wasn't his. It had another person's emails. He used the phone repeatedly for 2 days, as the call logs indicated. This man simply decided that he liked the phone and wanted to keep it for himself, in violation of Massachusetts General Law, Chapter 132, subsection 3F. As such, I would submit that Mr. Harris be found guilty of larceny pursuant to Massachusetts General Law, Chapter 132, subsection 3F.
Ms. Sims?
I can't really argue except one thing. Intent is an element of the crime. Specifically, there has to be concurrence between mind and act, which basically means that at the time Mr. Harris took the phone, he had to have the intent to steal it. The prosecution has offered no evidence to establish that. My client simply could have mistakenly taken the phone, thinking it was his own, then decided to keep it after realizing it wasn't his.
Well, he certainly had the requisite mental intent to deprive another person of their property.
But not at the time of the taking, which is the prerequisite for concurrence.
Even if that were a correct statement of the law,
It is.
He would still be guilty of possession of stolen property.
If only you thought to charge possession. You didn't. And you can't now because double jeopardy applies to the lesser includeds.
Your Honor, he knew it wasn't his when he took it.
You didn't establish that, Mr. Peters. And truth be told, you didn't even allege it. Ms. Sims is right. You didn't prove concurrence between mind and act. I have no choice but to enter a finding of not guilty. Mr. Harris, you are free to go. You got lucky this time.